Hello and welcome to April 2021's episode of My PIP Monthly. Today it's presented by Mark Master, Senior Partner, myself, Amber Rouse Holloway, a partner here at our Troy location, and with me I have a special guest, Caitlin Milroy. She's also a partner here at our Troy location.
Hello everyone, good to be with you.
Right. So, pursuant to our typical format, I'll be talking about a few case law updates. First, VHS of Michigan, DBA, the Detroit Medical Center v. State Farm. Then Roskamp v. Fremont Insurance Company. And lastly, Physiatry and Rehab Associates v. State Farm. And then, for trending topics in PIP litigation, Caitlin's going to take over and discuss the Michigan no-fault reform, specifically discussing the changes to come in July 2021. First up is VHS of Michigan, DBA, the Detroit Medical Center v. State Farm Mutual Automobile Insurance Company. In this case, the Court of Appeals reversed and vacated the trial court's decision to deny defendant State Farm's motion to amend its affirmative defenses. This case specifically talks about amending affirmative defenses and pleading fraud with particularity, and how important it is to do so when time permits. So essentially, defendants must plead fraud with particularity in their responsive pleadings or file for leave to amend as soon as information pertaining to the fraud becomes available to them. Pleading fraud outlines the who, what, where, and when defending a suit. Defendants must set forth these facts in their responsive pleadings if possible, but if it is not known, that is when you file the motion for leave. Should the information become available during discovery, defendants may move to amend their affirmative defenses at any time, unless doing so would prejudice the other party. Specifically in this case, there was obviously a motor vehicle accident that involved a Ferlita Reyes and 5 other passengers. Plaintiff, the Detroit Medical Center, filed suit against defendant, asserting that it submitted reasonable proof for the charges to defendant, and then defendant denied or delayed the payment. Defendant answered its complaint timely and assertive affirmative defenses, and did include fraud with those affirmative defenses, but failed to plead fraud with particularity. So essentially they didn't say what type of fraud, when the fraud occurred, or anything of that nature, just that fraud may have occurred. The parties engaged in written and oral discovery, depositions were taken, and then defendant moved to amend its affirmative defenses to plead fraud after obtaining sufficient information to assert specific findings. In support of its motion, defendant set forth pertinent evidence, which revealed that the passengers staged the subject auto accident to defraud State Farm. The defendant presented inconsistent testimony from the passengers involved, social media investigations, and an expert opinion which found that the accident was staged by the claimants. Plaintiff opposed defendant's motion to amend, arguing that the trial court should find the defendant waived the fraud of defense because it was not pled with particularity in its responsive pleadings. Plaintiff argued that the motion was untimely because defendant had gathered all the necessary information it needed, but waited until right at the end of the close of discovery to move to amend its affirmative defenses. Ultimately, the trial court agreed with plaintiff and denies defendant's motion. Defendant appealed the trial court's decision, arguing that the trial court abused its discretion by denying its motion, and the Court of Appeals agreed with defendant and reversed the trial court's opinion. Pursuant to MCL 2.118A2, a motion to leave to amend shall be freely given when justice requires. The court also discussed the Weimers v. Cara decision, which provides that delay alone does not warrant a denial of a motion to amend, and that a trial court must also find that the delay was the result of bad faith, or opposing party must have suffered a prejudice or injustice as a result of the delay. The Court of Appeals here ruled that the plaintiff did not suffer any prejudice, and therefore they agreed with defendant. The Court of Appeals recognized the defendant asserted fraud as an affirmative defense in its responsive pleadings, which put the plaintiff on notice that the defendant would be pursuing that particular defense. Next up, we have the case of Roskamp v. Fremont Insurance Company. This case highlights that an insurer is not necessarily precluded from rescinding a policy, even when a notice of non-renewal was issued prior to the rescission. Here, the court noted that the question of whether an insurer is precluded from rescinding the policy after cancellation or non-renewal has been issued will involve whether the insurer induced the insured into believing that coverage actually existed at the time of the accident. In Roskamp, plaintiff was injured in a motor vehicle accident as a driver listed under a policy of insurance issued by Fremont to Roskamp's girlfriend's parents. This case has a detailed procedural history and detailed facts, but essentially, Dexter, the girlfriend's parents, took out the policy of insurance with Fremont in December of 2015. After an April 2016 accident involving Roskamp's girlfriend, Fremont advised Dexter that all drivers in the household must be listed on the policy. Dexter then added the daughter, Roskamp's girlfriend, to the policy. Sometime in March or April of 2016, Roskamp moved into Dexter's home, and then in August of 2016, Dexter added Roskamp's vehicle to the policy of insurance, citing their daughter as the driver of the vehicle, but did not add Roskamp as a listed driver to the policy. Fast forward to November 7th, 2015, Roskamp was injured while driving his vehicle. After investigating the loss, Fremont discovered that Roskamp was living with Dexter and also that Roskamp had a very poor driving record. As a result, Fremont issued a notice of non-renewal to Dexter on November 14, 2016, so approximately 7 days after the accident. After continuing the investigation, including examinations under oath of Roskamp and Dexter, Fremont rescinded the policy, citing the material misrepresentations made by Dexter when obtaining the policy. Allstate Insurance Company was claimed through the MAIPF. Roskamp then initiated an action against Fremont seeking PIP benefits. Roskamp alleged that Fremont had been the insurer and that their rescission was unlawful. Roskamp later amended its complaint, adding Allstate to the accident, and then filed for motion for summary disposition, arguing that Allstate was first in priority. Allstate filed a motion for summary disposition as well, challenging the validity of Fremont's rescission and contending that Fremont was higher in priority. Ultimately, the trial court determined that Fremont waived its right to rescind the policy after it had already sent Dexter the notice of non-renewal. The thought here is that because of the non-renewal, the Dexter or the claimant may have assumed that coverage existed at the time of the loss. The trial court formed the basis of its ruling on the case of Burton v. Wolverine Mutual Insurance Company. In that case, an insurer issued a notice of cancellation to the insured, and the insurer learned of plaintiff's material misrepresentation related to their driving record and canceled the policy effective November 17, 1986. However, the plaintiff in that case was involved in an accident on November 8, 1986 and suffered injuries. The insurer in this case then rescinded the policy based on the same misrepresentations that formed their basis to cancel the policy. The Court of Appeals held that that was improper, and the insurer chose to bear the risk and keep the premium until the cancellation date, and thus rescission was not proper. Here, the Michigan Court of Appeals in Roskamp was tasked with determining whether Fremont waived its right to rescind the policy by first issuing a notice of non-renewal to its insured and then rescinding the policy. The Court of Appeals held that Burton was particularly distinguishable from the facts of Roskamp because in Roskamp, the insurer did not induce Dexter into believing coverage existed until after a particular date of the issuance of the non-renewal. Instead, after the accident, Fremont learned of the misrepresentation related to Roskamp and then issued the non-renewal notice. Then, after further investigation, Fremont rescinded the policy and refunded the premium, and this happened a mere 7 days after the accident. As such, Dexter did not rely on Fremont's non-renewal as the accident had already occurred. Therefore, the court held that Fremont was not precluded from rescinding the policy after having issued the non-renewal notice. The court went on to hold that because the trial court failed to consider whether Fremont would rescind the policy based on the policy language as it related to the current law. The case was remanded back to the trial court for further determination regarding Fremont's ability to rescind the policy. And lastly, we have the case of Physiatry and Rehab Associates v. State Farm Mutual Automobile Insurance Company. This case essentially places the burden on providers to timely file lawsuits or intervene into the main PIP case. It limits a provider's strategy in filing its own suit or intervening into the main suit. It also talks about filing the appropriate motion for summary disposition, defendants filing the appropriate motion for summary disposition in these provider cases in which the claimant has settled all of their past, present, and future rights to no-fault benefits. In the case of Physiatry, plaintiff treated a Lena Kasha after an automobile accident. Defendant insured Kasha at the time of the accident, and on November 17, 2017, Kasha filed suit in Wayne County against defendant, alleging injuries sustained in the accident. After suit was filed, Kasha sought treatment with plaintiff and executed an assignment. The assignment was executed specifically on November 5th, 2018. The assignment, of course, contained language stating that all of Kasha's rights to recover payment for all past and present services. Consequently, plaintiff then pursued its own lawsuit for treatment provided to Kasha in the Oakland County Circuit Court. Along with its complaint, plaintiff attached an assignment of rights and the itemized bill for services. Plaintiff served this complaint on defendant on February 25, 2019. Just a few days later, literally 2 days later, on February 27, 2019, Kasha and defendant appeared for a settlement conference and settled all of her outstanding claims. Kasha then executed a release effective March 5th, 2019, releasing all rights to medical benefits which had accrued through March 1st, 2019. In the release, Kasha represented that she had not assigned or transferred or purported to assign to transfer to any person or entity or claim or cause of action arising out of or related to the subject accident. A stipulation and agreement of dismissal was executed by defendant and Kasha on April 22, 2019. And then, consequently, in the provider suit, plaintiff moved for summary disposition, arguing collateral estoppel and res judicata, and essentially arguing that plaintiff's claims were barred by Kasha's release in the underlying PIP suit. Further, defendant argued that plaintiff's claim in the current suit was barred by the good faith settlement in Kasha's PIP suit. Defendant also argued that it did not have notice of plaintiff's claim prior to the Kasha settlement and prior to the settlement conference. Dates do overlap, however, it was just a mere 2 days after defendant was served that the case was settled. So it's unreasonable to think that the defense attorney would have known about the service of the complaint at that time. Despite plaintiff's arguments, the trial court sided with defendant and ruled that the plain language of the settlement agreement included all claims by Kasha and res judicata applied. As a result, the trial court granted summary disposition and denied plaintiff's claim for reconsideration. On appeal, plaintiff argued that the trial court erred in granting summary disposition for defendant because Kasha could not release a claim once assigned to plaintiff. Additionally, plaintiff argued that his claims did not arise from the same transaction or occurrence as Kasha's and were not ripe during settlement of the PIP claim. Ultimately, the Court of Appeals denied plaintiff's appeal and in its analysis argued or reasoned that plaintiff was well aware of Kasha's Wayne County suit and could have intervened in that suit, but chose not to. In choosing not to, plaintiff acquiesced to Kasha as the assigner to proceed on its claims. The decision to not intervene was a strategic decision, and that choice bound plaintiff to the terms of Kasha's settlement agreement for all PIP claims. Ultimately, we see this issue a lot in our provider suits that pop up, especially after we have settled the underlying claimant's claim for all past, present, and future no-fault benefits. So it is important to note when the insurer was made aware of the provider and how was the insurer made aware of the provider. If the insurer is unaware of the provider, motions for summary disposition based on res judicata and collateral estoppel are incredibly important to file at a timely basis.
Hi everyone, my name is Caitlin Milroy and I am a partner at the Seacrest Wardle Troy office. Today I have been asked to discuss specifically the changes that are immediately going into effect from the reform beginning July 1st, 2021. First, MCL 500.3137 has changed entirely with the passing of the reform legislation. Coming up as of July 1st, 2021, a physician, hospital, clinic, or other treatment provider that renders treatment or training for injuries arising out of a motor vehicle accident will be subject to a fee schedule. The amount payable under the fee schedule for these charges depends on the nature of the medical care provided. Providers will now be entitled to a different reimbursement rate if the service has a rate payable under Medicare. The new statute also provides other limitations and restrictions on benefits pertaining to neurological rehab clinics and attendant care that we will discuss. Lastly, within the statute, there is also a new administrative process for both an insurer or the MCCA to challenge the overutilization of services. Now, from the time that the Michigan No Fault Act was passed in 1973, the only limitation on the amount of a medical provider's charge arising out of a motor vehicle accident was that it had to be, quote, reasonable and customary, unquote. The issue with the prior statute is that determining a reasonable amount and determining what is customarily charged are two entirely separate standards. A provider could only charge a customary fee for its services, but an insurer could independently review and audit the provider's charges to determine reasonableness. As such, a provider's customary charge may be reasonable in one instance, but not in another. An example of this, a very common one, is an MRI facility charges $5,400 for an MRI, and an insurer pays $1,700 based on an audit of its charges. Litigation ensues for the balance based on no guidance on what is reasonable, and the matter settles for somewhere in between what was paid and what was charged. Over the years, a large body of case law has been created addressing what information could be considered to determine reasonableness. As of July 1st, 2021, we will see sweeping changes as to how treatment and services are being billed by providers. The statute as a whole of MCL 500.3157 remains relatively intact, but has expanded to include a fee schedule that limits reimbursement rates. That fee schedule applies depending on the nature of the medical care provided. When looking at the new fee schedules overall, we first determine if the charge is payable by Medicare, and if so, there is a percentage of that amount that becomes the fee. When Medicare does not provide an amount payment, in that instance, the fee is determined by a percentage of what we call the, quote, charge description master, unquote, or average charge. The charge description master is defined as a uniform schedule of charges represented by the person as its gross billed charge for a given service or item, regardless of payer type. There's no guidance on how an average amount charged by the provider is established, so that is left up to interpretation. In this instance, the rate is calculated by taking a percentage of the amount payable for the treatment or training under the provider's charge description master in effect on January 1st, 2019. If the provider did not have a charge description master on that date, then the percentage is taken from the average amount that the provider charged for the treatment on that date. The amounts in effect on January 1st, 2019 are also going to be adjusted annually for inflation by the percentage change in the medical care component of the Consumer Price Index for the year preceding the adjustment. The next few subsections of this topic will include very specific numbers with respect to the different fee schedules coming into play in July 2021, depending on the type of the provider facility performing the treatment and then billing the insurer. For purposes of limiting time, those specific fee schedules are directly contained within the prepared PowerPoint presentation for your reference, but I will briefly touch upon same right now. First, I list the fee schedule for indigent volume or freestanding rehab facilities. When a provider that has 20 to 30% indigent volume, indigent means looking to the amount of Medicaid recipients treated by a treatment provider. Or if it's a freestanding rehab facility, it is subject to a specific fee schedule spelled out in the PowerPoint slide. Per MCL 500.31574A, the indigent volume requirement is determined pursuant to the Department of Health and Human Services method in measuring eligibility for Medicaid. There are certain Department of Insurance and Financial Services, or DIFS, requirements. To qualify for the aforementioned fee schedule, a facility must submit documentation to the Director of DIFS, who will perform an annual review to determine qualification. DIFS is also not allowed to designate more than 2 specifically freestanding rehab facilities that will qualify for payments under this fee schedule per year. Freestanding rehab facilities are acute care hospitals meeting certain strict requirements, i.e. they were in existence on May 1st, 2019, and they have special expertise in rehab medicine. If the indigent volume for the provider is 30% or more of the total treatment or training, this fee schedule is ignored. Instead, that provider would be entitled to 250% of the amount payable under Medicare, or 78% of the charge description master/average charge on January 1st, 2019, if Medicare does not provide an amount payable. Next up are fee schedules for Level 1 or Level 2 trauma centers. Hospitals that are classified as Level 1 or Level 2 trauma centers now have their own fee schedule in place, and that is spelled out in MCL 500.31576 and MCL 500.31577D. Like with the prior fee schedule we discussed, we first look to the amount payable by Medicare and then to the charge description master/average charge on January 1st, 2019 if needed. In order to be subject to this particular fee schedule, the treatment must be for an emergency medical condition and rendered before the patient is stabilized or transferred. If not, then this fee schedule does not apply. The statute refers to the Social Security Act's definition of what constitutes as an emergency medical condition, which is a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, such that the absence of immediate medical attention could reasonably be expected to result in 1. Placing the health of the individual, or with respect to a pregnant woman, the health of the woman or her unborn child in serious jeopardy, 2. Serious impairment to bodily functions, or 3. Serious dysfunction of any bodily organ or part, or with respect to a pregnant woman who is having contractions, that there is inadequate time to effect a safe transfer to another hospital before delivery, or that transfer may pose a threat to the health or safety of the woman or the unborn child. The statute also defines the terms stabilized and transfer per the Social Security Act's definitions. Stabilized means that no material deterioration of the condition is likely, within reasonable medical probability, to result from or occur during transfer from a facility, or in the instance of pregnancy the woman has delivered. Transfer means the movement, including discharge, of an individual outside a hospital's facilities at the direction of any person employed by or associated with the hospital. For medical providers that do not fall into either of the categories we have already discussed, they are also subject to a fee schedule that provides lower reimbursement rates, per MCL 500.3157 subsection 2. Examples of these providers include standard physicians, traumatic brain injury facilities, guardians/conservators, case managers, and home modification contractors. Again, we first look to the amount payable by Medicare and then to the charge description master/average charge on January 1st, 2019 if needed. This fee schedule also applies to treatment or rehabilitation occupational training rendered after July 1st, 2021, unless this treatment was for emergency medical services. MCL 500.3157 subsection 13 exempts ambulance or medical emergency services only from the fee schedules that we have discussed. Now on to the issue of attendant care and the changes with no-fault reform. Attendant care is a, quote, allowable expense, unquote, under MCL 500.3107 subsection 1A, and prior to reform was not subject to any specific limitations in amount or duration to the extent that the benefit was payable. As of July 1st, 2021, the hourly cap for non-agency family and friend provided attendant care services is now 56 hours per week, which is essentially 8 hours per day under MCL 500.3157 subsection 10. This cap was actually taken directly from the restriction provided in the Michigan Workers' Compensation Act. This limitation relates to attendant care provided in the injured person's home. It is currently unclear whether the limitation applies when the care is provided in someone else's home. We will more than likely receive more clarity in that regard when the issue comes up in litigation and the new cap takes effect. This limitation only applies to attendant care provided directly or indirectly through another person by any of the following individuals listed on the slide, but in some family and friends. So this can include an individual who is related to the injured person, an individual who is domiciled in the household of the injured person, or an individual with whom the injured person has a business or social relationship before the injury. This 56-hour limitation appears to further apply to scenarios where a family member is performing attendant care for an injured person through an attendant care agency. Nurse or aide provided care through an attendant care agency is excluded from this limitation. An insurer can still contract to provide benefits in excess of the new hourly limitations. A likely example of this would be when someone is catastrophically injured who has a policy providing lifetime allowable expenses. An attendant care agency or inpatient facility would likely charge a very high rate for such continued care, as compared to a family member or a friend without any special or medical training or licensure. So this negotiation tactic past the cap could potentially produce long-term cost savings for an insurer, continue reimbursing attendant care claims in excess of 56 hours per week. Next, we are going to discuss neurological rehabilitation accreditation. The new version of MCL 500.3157 also introduces the concept of these clinics, which are defined as a person, including an institution, that provides post-acute brain and spinal rehabilitation care. Such clinics will more likely fall within the general fee schedule, as it is fairly likely that the services provided would not have an amount payable under Medicare. Such clinics must be accredited by the Commission on Accreditation of Rehabilitation Facilities or a similar organization recognized by the Director of DIFs. Accreditation requirement does not apply if the clinic is in the process of becoming accredited on July 1st, 2021, as long as 3 years have not passed since the beginning of that process, and the clinic is still not accredited. Next up, we will talk about utilization reviews. With all of the new changes regarding these new fee schedules, there are bound to be some anticipated hiccups with respect to the set amounts paid to medical providers. MCL 500.3157A is a new subsection to the statute as a result of the legislative reform that provides some protection in this regard. Now, providers are required to submit to utilization reviews if requested by an insurer or the Michigan Catastrophic Claims Association, or the MCCA. A utilization review is defined as the initial evaluation by an insurer or the MCCA of the appropriateness in terms of both the level and the quality of treatment, products, services, or accommodations provided based on medical accepted standards. The new subsection applies to treatment, products, services, or accommodations provided after July 1st, 2020. The MCCA may require a provider to explain the necessity or indication for treatment in writing. This is usually triggered if a provider provides treatment, products, services, or accommodations that, 1, are not usually associated with the diagnosis or condition for which the person is being treated, 2, are longer in duration than the diagnosis or condition for which the person is being treated, 3, are more frequent than the diagnosis or condition for which the person is being treated, and 4, extend over the greater number of days than usually required for the diagnosis or condition for which the person is being treated. If the MCCA or an insurer deems treatment to be overutilized or inappropriate, or the cost to be inappropriate, the provider may appeal the decision to DIFS. The use of the word may here is telling, as it suggests that this is not a mandatory process that needs to be exhausted pre-litigation. This is likely to result in litigation dispute later on. Providers do have to tread lightly here, though, because knowingly submitting false or misleading documents or other information to an insurer is a punishable fraudulent activity. Any provider who has rendered treatment to an injured person covered by no-fault insurance is considered to have consented to submit documentation for a utilization review and agreed to abide by any decision rendered by DIFS. There was recently a challenge to the constitutionality of the reform changes about to go into effect this July. In Andari AL versus USAA Casualty Insurance Company out of the Ingham County Circuit Court, Judge Wanda Stokes rejected the plaintiff's claim that certain amendments to the No Fault Act were unconstitutional. The challenged amendments related directly to the constitutionality in general of the fee schedules and their retroactive nature, along with the 56-hour attendant care cap. In Andari, plaintiffs claimed that these amendments violated the Michigan Constitution's substantive due process, equal protection, and contract clauses. On November 13, 2020, the Circuit Court found that the 2019 amendments were a valid exercise of the legislature's prerogative to limit, quote, costs and fraud in the no-fault system to make insurance more affordable, unquote, noting that, quote, such cost containment measures have been upheld, unquote, by the Michigan Supreme Court. We are going to be seeing a lot more of these reform changes pop up in litigation in the future. The fee schedule aspect is obviously going to be something, for the most part, handled by an insurer's billing department and obviously pre-litigation. While I do think that we will generally see an obvious decrease in provider actions in the future, given the fact that balance billing suits will become mainly obsolete with the fee schedules, I do anticipate that there will likely be more legal battles to come between providers and insurance companies relating to the amounts reimbursed. We will certainly stay tuned for those developments.
Thank you guys for joining this month's episode of my PIP Monthly. The takeaways from today's presentation are to make sure you plead fraud and amend your affirmative defenses as soon as any information regarding fraud is available. Also, an insurer is not precluded from rescinding the policy after having issued a notice of non-renewal or cancellation, as long as that the insurer did not induce the insured into believing that coverage did exist at the time of the loss. Also, it is important to draft releases with specific language and to be diligent about raising res judicata arguments in provider suits and in following motions for summary dispositions. Thank you. And thank you all for attending my PIP Monthly. Please contact us with any questions or comments you may have. Thank you.